everyone. I would like to welcome you to this event on behalf of Sydney Law School and on behalf of the Ross Parsons Centre. We are really so privileged this evening to have the Honourable Ray Finklestein QC and the Honourable Robert Austin to discuss issues relating to corporate governance and the Board of Directors. Both these speakers really, truly need no introduction, and I'm not going to introduce them, apart from to say they are, the greatest legal polymaths that I know. They have really explored so many different arenas of the law, and it is a great privilege to have them here. Now, just to set out the format of this evening, we are going to have an hour and a quarter of dialogue, and we would be very delighted if the audience would like to participate. We're basically going to go through, time permitting, 6 key areas. We're going to look at the history of corporate governance. We're going to look at composition of the board, focusing on independent directors. We're going to look at the relationship between the board and management, the chair, and we're going to look at delegation and reliance, and finally, a very practical issue for directors, workload problems and workload solutions. So I'm going to move off now, and we're going to start. I would like to very much thank the Chief Justice for allowing us to move tonight's seminar into the newly refurbished court, and we're very grateful to be here. Mobile phones off. If anyone has forgotten to do that, now is a good time. I'm hoping I've turned mine off, but we'll soon find out. And I'm going to move on to this first issue, which is just by way of background and introduction. There was a time where, like the term fiscal cliff, we didn't know what the term corporate governance was. It seems a very long time ago. We've lived with it for a long time. But I'm going to just ask Ray or Mr. Finklestein? Ray, I'm going to ask Ray to give us his take on the trajectory of corporate governance. Is it really important? Should we still be worried about it, or has time moved on and it's all financial market regulation now?
Thanks, Jenny. I thought it might be useful just to say something about what is commonly understood as corporate governance, because like many expressions, it's got a variety of meanings and it could be inherently ambiguous. From an economist's viewpoint, corporate governance is designed to deal with the so-called agency problem. And in case of companies, it's the relationship between managers and the shareholders. Some writers take corporate governance back to 1776 and the writings of Adam Smith, who was concerned about directors of companies being managers of other people's money and never being in a position to deal with other people's money in the same way as they would with their own. In more modern times, probably one of the best descriptions of corporate governance comes from the 1992 English Cadbury report, where it was described as a critical aspect of the system by which companies are directed and controlled. In other words, direction and control are the cornerstone of governance of corporations. That direction can be both internal, the mechanics of corporate decision making, and external, which would include regulatory requirements. Company law in our country focuses power in the hands of the directors, but the directors delegate much of their authority to officers who fill out the rest of the management team by hiring and firing relevant staff. The corporate government principles provide a framework over the long term for managers, the board, to optimise performance and accountability. Appropriate internal mechanisms are critical. For the most part, central decision-making of the board is a black box, not open to scrutiny by shareholders, rarely open to scrutiny by judges, or indeed by anybody else. I don't know how many minutes I've seen where an important topic is mentioned as on the agenda, and what follows is discussion ensued. and I've always thought, both as a judge and as a lawyer, that the purpose of that is to keep the discussion secret, lest it prove to be harmful to the company or to the board. The idea of corporate governance, though, raises more than just mechanical questions about how a company should function and how a board should operate and what relationship a board should have with other management within the corporate entity. The question is, for whose benefit should there be optimal performance, and to whom should management or the board be accountable? The prevailing theory in Australia and prevailing theory in England, but not universally so, is that the responsibility of the board is to maximise shareholder wealth. Creditors get a look in if the company is insolvent or near insolvent. The reality is, though, that there are many other important groups who, either more or less immediately, are affected by and significantly affected by decisions of the board. They include, obviously, employees, suppliers, customers, the community through the effects of a corporation on the environment, and at a very general level, society as a whole. Interestingly, in England, the responsibilities of a board to more than just shareholders is given statutory recognition by Section 172 of the 2006 Act.
Well, I want to come back to you on that point, Ray, if I may, in a moment.
Yeah.
I'm just going to pass it to Bob Austin now. Bob, do you have any framework or historical comments that you want to make?
Just a couple, thanks, Jenny. I noticed that Ray's list of stakeholders ended with society as a whole. I would urge him to begin with society as a whole. The Economist produced an analysis of the importance of public companies in May this year, and they concluded in this way: public companies built the railroads of the 19th century, they filled the world with cars and televisions and computers, they brought transparency to business life and opportunities to small investors. Because public companies sell shares to the unsophisticated, policymakers have a right to regulate them more tightly than other forms of corporate organisation, but not so tightly that entrepreneurs start to dread the prospect of public listing. A public company has long been the locomotive of capitalism. So the economic interests of the society, I think, are at stake, very much at stake in our debate. I don't mean to downgrade what Ray said about the importance of other stakeholders. There is an issue we can debate about whether they should be written into the law in terms of directors' duties, but nonetheless they're important. But I start with the proposition that we are tinkering with issues that are fundamentally important to the Australian economy. And the other thing I wanted to say is this, that I think there's a perspective arising out of the Cadbury Committee that we should remember. I believe that the modern concept of a board of directors of a public company has changed during our lifetime. I should say it's a delight to appear here with Ray, because he and I are living evidence of the importance of the year 1946. And beyond that, he's the only person I can recall in living memory who's responded with some recognition when I talked about the immortal Crash Craddock. You see? But what's happened, I think, is that the concept of the public company was in the 19th century moulded by the joint stock company in the United Kingdom. It was very much the case that the board was management in committee. We might have seen some notables in the board put there because of their contacts or their titles, but essentially it was a management body. And even in the 1930s, when Burley and Means wrote their seminal work, it was a case of analysing managers versus shareholders without any concept that the board was somehow in the middle, acting as monitors of management for the benefit of shareholders. And that idea has developed only more recently, and I believe was crystallised for the British Commonwealth at least, after academic writings in the US, crystallised for the British Commonwealth only in 1992 when the Cadbury Committee wrote.
Okay. I totally agree with your point there about the divergent development of the corporation in the UK and the US. I do think in the UK it was very much a partnership model, and so I think shareholder interests were predominant in that model, whereas in the US I think it developed as a management-centred vehicle. And you see that in a range of ways. But I want to take up the point that you both made about to whom do the directors owe their duty, and also the changing shape of the board over time. And this shift that we've seen towards independent directors, because I think that has been really at the forefront of changes to the board of directors and potentially to directors' duties. And I want to go back 30 years, a very famous article by Victor Brudney in the Harvard Law Review in 1982 called The Independent Director, Heavenly City or Potemkin Village, where Professor Brudney said he predicted that independent directors would become the predominant monitoring mechanism for the corporation. But he said there are 3 possible monitoring roles they can have. One is monitoring managerial integrity. Secondly, monitoring corporate performance. Or thirdly, monitoring corporate social responsibility. And I just want to ask our speakers, do you see that in the current commercial world, and which of those themes that Professor Brudney identified do you think we're really witnessing today? So Ray, maybe over to you first.
I accept that in the last 20 years or so, it's been very fashionable for regulatory agencies and for public companies themselves to move ahead with the idea of an independent director. And most public companies have independent directors, whether they're large public companies or small. I see some problems with the role of an independent director. I think that the role is ill-defined. I myself would favour a proposition that a director who is independent of the day-to-day management of a firm is potentially in a good position to monitor performance. And if I was to be asked what I thought was the central role of independent members of the board, it would be monitoring performance. The downside is that how does an independent director, that is a person who has had little or no connection with the company, monitor anything when there will be a complete lack of detailed information about the affairs of the company? So that if you're going to monitor performance in any sense, in any real sense, then the first obligation of the independent director is to get on top of what are the affairs of the company in some detail. Otherwise the independent director doesn't have a useful function to serve. And there's nice questions then about the liabilities of so-called independent directors, that is those who don't do what I think they should do as a matter of legal obligation, that is get on top of the affairs of the company. So I think they have a role, and they may have an important role because I fear, generally speaking, that those who are involved in management decisions don't necessarily bring an objective view to bear on all issues, and something that an independent director can do is provide a degree of objectivity to board decision making. My worry is twofold. One, whether independent directors are ever equipped fully to be able to perform their task. And secondly, I've looked in recent times to see whether there's any data published on the effectiveness of independent directors as opposed to their fashionability. There's no doubt that they're very fashionable, but I'm not sure whether there's any material that says that they bring about any significant change to the operation of a firm or to the workings of a board. In other words, do less companies collapse? Do less companies make bad business decisions, and so on, which is, I suppose, what one would expect if the theory of the independent director works. I'm just not sure whether it's true or false in an empirical sense.
I think there are some finance professors who are trying to make their careers answering that question, but I don't think they've got there yet.
It's been going on since the 90s,
Yeah.
trying to link independent boards with better performance.
I mean, look, there's a lot that Ray said that could be responded to, but can I cut through a lot of the issues to say this? I think in the last decade anyway, what we've seen developing in Australia, from what I've gathered talking to directors recently, is that there is a class being consolidated of professional non-executive company directors. They are independent if what you mean by independence is some distance from active management. I know there's a definition in the ASX corporate governance principles and recommendations and elsewhere. I think you can get too bogged down in the details of those definitions, but I agree with Ray that an important component of the modern non-executive company director class, if I can call them that, is to be a bit distant from management so they can review management objectively. Interestingly, as I see it, because of the growth of the legal requirement of an objective standard of skill, particularly in financial affairs, there are more than ever recognised qualities that those looking to fill board positions take into account, which are common to the class of professional non-executive company directors. I think that's an important development, and we'll come back to it later when we talk about overload, because if you combine it with the proposition that those people are getting increasingly subject to an overload, what we're seeing happening is that those professional non-executive directors as a class are becoming almost full-time professional, quote, non-executive directors. And that's an important development. It sets standards, but I think Ray and I would agree, we were talking about this afternoon, that there's a qualification to the proposition that board directors should be professional non-executive directors in this sense. It is you have to have on the board some directors who understand the way this company works in great detail, and the others who don't, when they're put on the board, need to catch up.
From my perspective, a long time ago, having had clients who were members of boards, found that those who were best at decision making were those who had worked in a particular industry. So that if you ran a steel mill, then if you were an engineer, you could make decisions about the steel mill. If you ran a cardboard box making plant, if you were involved in that kind of business for a lifetime, you made proper business decisions. If you ran a rag trade business, in the rag trade all your life, you made better decisions. Now, that's not to say that those kinds of people who I think probably make the best chairs, subject to personality issues, for those kinds of concerns, obviously need other assistance for the skills that they don't have. And I think that the rest of the board can include people who provide the necessary skills. So if you need a chief financial officer who's on top of modern financing techniques and so on, to provide advice which the person who knows the business doesn't have. So I think a good board would have complementary personnel of the kind needed to make that particular business operate. But I think that the main decisions, or the better decisions, I shouldn't say the main decisions, the better decisions are made by those who understand the business.
Can I just make one point, Bob, and then I'll pass it over to you again. Just on this idea, I think there has been a backlash against independent directors being the panacea to all things, and particularly since the global financial crisis in the banking realm, there's a lot of interest now in bank governance, and people are really stressing that expertise is much more important than independence. So I think that's quite important. And I think it was something that really the Hicks Committee, what year was the Hicks Committee in? You talked about it in ASIC and Rich in 2002. Yeah, 2003 or so, I think. Yeah. And the Hicks Committee really made the point that if you have supermajority boards, which most US companies do because they are required to have fully independent committees, that it's more easy for those boards to be duped if you have just a couple of executives. So, that's another side to the independent. No, over to you, Bob.
Well, I want to get this debate cracking along, so I want to accuse my colleague here of being old-fashioned. I think his view of the board, where you have experts from the industry or from the business concerned, and then you pick a few other experts and put them on the board as well, is yesterday's idea. I had this debate recently with a senior company chair who was taking the same view as Ray, so there's certainly room for that view to be held. But what I would say, as I indicated earlier, is that there are now identifiable characteristics for the professional class of non-executive directors. I'm not so fussed about the independent component of it, but I see levels of objective skill being required, skill which includes understanding the company's business, skill which includes also, I think, understanding how to run companies of that kind generally in that industry and even across industries. And so I think they're the sorts of requirements that you need to balance the skills that the engineer who's run BHP all his life, or at least he's been in BHP all his life and now he's on the board. You need other skills of this kind to balance that requirement. Can I say one other thing about directors which distinguishes them from executives, and this might lead us into another subject, and it's this. I think that the board's responsibilities are defined by the way in which they make their decisions. They proceed by board meetings and other board occasions. It's a collegiate arrangement in which the information input is essentially defined by the board papers and other information is injected into their activities in the boardroom. That's quite different from the executive on the job every day.
And I think that leads into the interesting issue of, if we have had this shift in the composition of the board towards independent directors, what do we view the role of directors as being these days? And do we want them to be involved in strategy? Do we want independent directors to have their fingers in those pies? And even more so, what do we do if there is fraud or wrongdoing in the company? I mean, you've just said, Bob, that you expect, the directors to be constrained by board papers. Some people would say no, if they're doing their job, they should be going and interviewing middle management, because they're the people that know what's going on the ground. So who wants to respond
Well,
to that?
I just deny that that's their function as individuals. I see their function is to operate as a group. What do you say, Ray?
I don't disagree with that. I think the board's there to operate as a group. It raises a very nice question: what is it that it ought to be their true function? And most of the statements that I've read in various reports that have investigated the operation of companies under the guise of corporate governance put supervision as the key or only function of a board. And once again, it's a proposition with which I strongly disagree. I don't agree that there should be a complete separation between supervision on one hand and management on the other. I'm not suggesting that the board should have any active role in the day-to-day management of the affairs of the company, but if I look at it from the perspective of an ex-judge who used to look at directors' conduct and read some of Bob's judgments in the area as well, there are, and I'm not just talking about the sort of centro and view of irreducible...
I didn't do that one.
No, you didn't. The irreducible decision-making which the board can't shift on to somebody else. I think that there are inevitably going to be key decisions, key business decisions, which a company faces, which ought to be taken by the board. And I've seen too many companies where the board meets once a month or once every 2 months. The board papers are delivered a couple of days or even a week beforehand, probably too long for anybody to read, often not with useful summaries, but decisions worth hundreds of millions of dollars, decisions worth billions of dollars taken at a meeting that takes place over a period of a day, sometimes for long board meetings, over the space of 2 days. I find it staggering that a board of any concern can make a decision to acquire an asset for $2, $4, $5 billion, or sell an asset for $2, $4, $5 billion, and take that decision over a period of a day when a whole lot of other business is dealt with, or 2 days when they're really long meetings. So I think that the idea that boards can move towards a position where they are nothing other than supervisors of very clever decision makers within the organisation is wrong as a matter of responsibility and likely to be very wrong as a matter of law.
I think there are two questions in all of that. One is the response to Jenny's question, which is how does the board make sure that there's not fraud in the corporate organisations if they're only meeting regularly in committee in board meetings and receiving board papers? And surely the answer to that is that the board has to design, with the help of management, effective compliance and risk management systems rather than to get into the day-to-day nitty-gritty of kicking the tyres and checking the cash registers to make sure that there's no cheating going on. It's the board's responsibility to be accountable for the compliance systems that are in place and the efficacy and working of those systems rather than with the actual implementation. The second issue is really very interesting and goes to the heart of our problem today, and that is whether there are core irreducible requirements for directors to deal with which can't be delegated to management. But Ray, I ask you rhetorically, what about section 198D of the Corporations Act, which basically says unless the Constitution provides otherwise, and it almost never does, the board can delegate to anyone?
Well, I've got a nice legal answer to that, but then you'll disagree with that like you have with very many other legal propositions I've put forward, which is an empowering section, but it doesn't say when it's appropriate to delegate functions to somebody else. So that in theory the board can delegate anything. There's no limit in the statutory language, but there will be many examples of specific decision making, subject matter, which it would be in breach of the board's duty or the director's duty to delegate to either a subcommittee or to an individual or group of individuals or bankers or whoever it might be.
I think that's the answer, isn't it? That's the key to it, that while there's an empowering provision, there's still a duty of care and diligence, which I think has the implication that there are some things that it would be unwise for boards and probably in breach of their duties to delegate to some committee even, or certainly management down the line. And that's what we have to take it Chief Justice Spiegelman meant, I should say, when he spoke in this very room about core irreducible requirements in Deputy Commissioner and Clerk, in an expression that was then taken up by Justice Gazelle in the James Hardy case and given some further currency by Justice Middleton in Centro. It's really properly analysed, not about power, it's about directors' duty of care.
Well, we're going to get to that and some of those cases a bit further down the track, but I just want to go back to the structure of the board for a moment. Should we be able to envisage a different structure that might be more effective? So, for example, Bob, I know that you've been looking at charters, the role of charters perhaps, and what about the role of, for instance, two-tiered boards? Might those different models, such as a two-tier system, which we see in Germany and we see in Switzerland, I think, and in other parts of Europe is an option. Would you like that, Ray? Would you like that?
I've seen attempts to do a comparison between our one-tier and the English one-tier system on one hand and some of the European two-tier systems, and nobody's been able to point to which is the better, at least at an objective level. But having a board or having two boards, one split between supervision and the other management, does exactly what I think a board should not do. It splits the functions which I think should not be split. So if there was a vote on it, I would vote against it. I don't think that a system which has a bifurcation between looking at overall policy and direction on the one hand and not having a say in important management decisions will work. But then there's no empirical evidence to say whether I'm right or wrong.
Bob?
I think the supervisory board concept has to be further defined, because it's like talking about a referendum on the Republic. It can mean a whole lot of different things depending on what that definition comes out to be. If we're talking about the German model, where you have worker representation on the supervisory board, there will be some reaction against that in Australia. And I think that model succeeds, if it does succeed, because of cultural circumstances that are probably not present here. So I would be very cautious about that kind of supervisory structure. And I agree with Ray that it's important, I think, to have a board that has the authority to demand respect amongst the management ranks. I think there's always a risk that management will tend to be sceptical of the board and not give them the opportunity to lead in the way they should. If you take away all actual decision making and just make them purely supervisory, there's a risk that the board will deteriorate in stature. So I don't like the supervisory board concept, but I do believe that we should try to align the responsibilities of boards of directors with what corporate governance says they should be. And corporate governance doesn't, as I read the literature, confine the board to pure supervision. Corporate governance does allow for important decisions to be made by the board, and it's that combination, important decisions to be made by the board, plus compliance, risk management, supervision systems properly established, and also obviously, crucially, the function of hiring and firing the chief executive. Those sorts of things, I think, should be defined as the functions of the board. I believe that it's time to move away from the concept that the board of directors manage the corporation, or even that the corporation is managed by or under the direction of the board of directors, which is what replaceable Rule 198A now says. The concept that the board of directors directs the management of the corporation necessarily implies that management, the executive team, are a corporate organ, because they receive the directions and then they go out and do the management. Once you accept that proposition, then you need to define more closely what the relationship is between those who issue the directions and those who do the management. And I think the way to achieve that is to define the responsibilities of the board of directors of a listed public company, which is what I'm talking about, with more precision. I would be guided by the literature in corporate governance as to how that definition would be made. I find a good starting point is the list in the corporate governance principles and recommendations of the ASX. You could achieve what I say should be done by amending the corporations law, by changing section 198A and perhaps having a more sensible replaceable rule, or even a mandatory rule for listed public companies. An alternative way of doing it, I believe, is to amend the corporate constitution.
Okay. Well, I think you raise an interesting point that traditionally we've looked at the board of directors and any corporate law textbook you open has got a huge amount on the board of directors but very little on executive officers, so that perhaps is the future. I want to move on now to another critical development, I think, in English and Australian corporate governance, but not in US corporate governance, is the increasing stature of the chairman. Bob, you talked about this in ASIC and Rich back in 2002, the fact that the role of the chair has changed greatly. I want to ask you both, how important do you think the role of the chair is on the ground in Australian companies, and which way is it heading? Who wants to start?
I don't think there's any real contest about the issue now. If you look at what chairmen of listed public companies now do, it is, I think, categorically different from what other non-executive directors of the company do. In the first place, the tradition now is that the chair is a member of all board committees. In what I think is now the common structure, that's not the case for other non-executive directors. They might be a member of one or two committees, but not all of them. In the second place, the chair not only chairs full board meetings, but is expected to provide leadership. The literature points that out all the time. The chairman is expected to superintend the documentary presentation of issues, make sure that the board papers are in proper order. Perhaps more importantly, the chair is a point of liaison between the management team and the directors, and also a point of liaison between the board and the shareholders, and in particular institutional shareholders. Quite a fulcrum in the operation of the boards and the company's activities. That seems to me to carry with it a special level of responsibility.
Any comments, Ray?
It's impossible to disagree with that. The degree of responsibility, which is much greater now than it was in the past, necessarily carries with it a greater degree of legal responsibility if things go wrong. And so that's the sort of spin-off result of the changing role or the increased role of a chairman of a board. I'm also interested, though, in the relationship between the chairman, either the chairman alone and the CEO, or the chairman and board and the CEO, because there is often a great deal of conflict. I don't mean nasty conflict, but between...
Not always.
Not always, true. But between the two positions. I said to Bob earlier this afternoon that I thought that a CEO gets into the job by force of a powerful personality. And the CEO will exercise that personality against even a powerful chairman. And it can lead to a great deal of strife within a commercial organisation if the chairman and the CEO don't get on. And part of the problem is the CEO often thinks that he or she is the boss, where it's really the chairman and board. But many CEOs think that they run the show, and in the management sense, they do run the show. Part of the problem, it's a point that I alluded to earlier, is I have been very surprised, I don't know whether it's the norm or not, the power that is delegated to the CEO to make decisions of significant financial consequence to bind the company. That is, the CEO makes decisions that often don't go to the board. The CEO might have authority to spend 20 million or 50 million of the company's money without reporting back. It's just part of the role. I think a great deal of care and attention ought to be given by boards to the precise powers and authorities rather than powers that are conferred on a CEO. Very, very often they seem to me to be far beyond what they ought to be. In a sense, the CEO is taking over some of the functions that would properly be remaining with the board and with the chairman.
Ray, if the board can't trust the CEO to spend $20 or $50 million, when the materiality threshold for the company is $200 million plus, they should sack him or her.
Yeah, that's one solution. The other solution is to make sure the show operates properly before you get to need to sack anybody.
I do find it interesting, though, that in the US there is still great resistance to having a chair. And I think it is because, you know, American companies still do look for the charismatic CEO. And so even though they've gone the route of a lead director, they are still resistant to this check and balance on too much centralised power that I think we see under the English and Australian models. In the midst of all this water passing, I'm now going to move on or move back to delegation. And this was obviously a matter that was of great interest to directors in Australia after that central watershed case in the mid-1990s, AWA and Daniels and Anderson. The issue was, is there a safe haven for directors who delegate? And what are the contours of that? And of course, we got statutory amendments around that time. So let's go back to this idea of what's core, which can't be delegated, what can be delegated, and when is a director going to be protected? Who wants to kick off?
Well, can I just repeat what I said before, which
Sure.
is that as a matter of power, I think that there's nothing that can't be delegated, but as a matter of responsibility and wisdom and duty, there are limits.
Do the statutory provisions set out those limits?
No.
No, they're in the general law.
Yeah, they're in the formula that Chief Justice Spiegelman enunciated about core irreducible requirements. But that's not all. And see, the other thing is you have provisions that say, yes, you can delegate anything. That's the first proposition. The second proposition you have is that, by the way, under Section 190 of the Corporations Act, you remain responsible for certain things unless you can establish criteria. The criteria are that the director believed on reasonable grounds at all times that the delegate will exercise the powers in conformity with the duties of directors. What on earth does that mean? And why is that significant? But the second requirement, the director believed on reasonable grounds and in good faith, and after making proper inquiry, if the circumstances indicated the need for inquiry, that the director was reliable and competent in relation to the power delegated. Well, when does that belief have to occur? Are we talking about when the delegate acts, or are we talking about when the delegation is made? It really does have the smell about it of something that hasn't been properly thought through. But we know that there's a statutory responsibility that you don't get rid of unless you can prove those vague criteria are satisfied. But then on top of that, and this is the point that people always miss when they talk about delegation, on top of that are the duties of the directors. They might have the power to delegate, but they have to do that for proper purposes, bona fide in the best interests of the corporation and with due care and diligence, and avoiding misuse of position.
I agree with that. I would add this gloss. It would be very wise for most public companies, if not all, to have in place a relatively firm, I intend for it to be only relatively firm policy about what kinds of decision making is to be delegated and what kinds not to be delegated. In other words, delegation shouldn't be on an ad hoc basis, but it should be pursuant to a thought out policy of the kinds of topics or subject matter or issues which the board, as a board, decides is appropriate to delegate to others within the organisation, whoever it might be, whatever part of management it might be. There's a risk, of course, once you have an internal policy, and there's no reason why it shouldn't be transparent, there's no reason why it shouldn't be a published policy. Bob has decided that those sort of policies then can set a framework about proper and improper conduct, so that if there's an action against directors for breach of duty, you can look to the policies that were in place to see whether they are complied with or not complied with. That's not a good reason not to have a policy. It's smarter, I think, for these kinds of issues to be dealt with as a result of a thought-out process rather than happenstance on a sort of decision-by-decision issue. But there's a price you pay which the legal system will extract if something seriously goes wrong. But then the answer to that is, if something seriously goes wrong, you should pay the price.
Yeah, well, what you say about policies really extends beyond instruments of delegation and the policy surrounding actual delegations, which hopefully our leading public companies have properly in place, to charters of various kinds, the board charter, the board committee charters and all of that. I think it must be the case that those are admissible in evidence when you're assessing whether the directors have complied with their duty.
I just want to tie what you've both been saying into another development of corporate governance over the last couple of decades, which is the move towards specific committees. And we're seeing the shape of committees changing somewhat since the global financial crisis, a lot of focus on risk control, etc. But I'm thinking specifically in the US of the Disney case, where Justice Jacobs in the Delaware Supreme Court, one of the reasons he said the board was not liable was because the remuneration decision that was at issue there, $123 million for 11 months' work or whatever it was, that had been delegated to the Remuneration Committee. And I don't think under Australian law, mere delegation to a committee is going to get the rest of the board off the hook. But clearly under US law, Justice Jacobs thought it did. So I'm just interested in your views on that.
Well, it depends on the circumstances so far as breach of duty is concerned. I mean, the starting point is that if you satisfy the criteria in section 190 and the delegation is authorised by the Constitution, then you may be off the hook unless in the circumstances you fail to properly consider the interests of the company or you've made a delegation imprudently. But the other thing to remember is that most board committees in Australia, if you have a look at their charters, don't have any delegated authority or very little. Their function typically is to recommend back to the board, and the board makes the decision.
And that might be a mistake if board members want to protect themselves and not have to go and sit in on every audit committee meeting, which apparently is what they're doing since the Centro case.
Well, I've been through the exercise with boards of seeing whether they can delegate more to their board committees, and there's quite a considerable resistance to doing so. In some circumstances they can't. The basic function of the audit committee is to make recommendations concerning the annual and half-year financial statements. The board has to provide a director's declaration. They can't delegate that function. So there's one thing that you really can't delegate to a committee. Boards are very reluctant to delegate OH&S to a committee because now, under the legislation, they have responsibilities as officers which really bump the responsibility up the corporate chain, including the board of directors themselves. So although they theoretically can delegate those functions, they're not likely to want to do so. With remuneration, the position is that they face the 2 strikes rule now. It's really a matter of high consciousness amongst boards, and they're not likely to sign off and say that you can go off and decide it and do it yourselves when we're at risk of being sacked.
Right?
Yeah, it's interesting in this context to notice that the listing rules of many exchanges recommend, some require, but most recommend subcommittees for audit, remuneration and appointments. And the listing rules contemplate the possibility that that's by delegation rather than just to, as a first port of call, to look at the issue and report back to the board. There may be a natural reluctance for boards to delegate the power, but the stock exchanges, many stock exchanges around the world think that's perfectly okay. There's always this override. I think that all of the listing rules that I've looked at say that these committees ought to be populated by independent directors. So they think that the listing bodies, the stock exchanges, think that these are peculiar, the kinds of decisions that are peculiarly left in the hands of people who've got nothing to do with management. That may be a good thing, that may be a smart thing, it's at least the underlying philosophy behind the listing rules, and it mightn't be bad, and it might be almost a safe haven for the rest of the board, not for the independent directors who make the decision, who are members of the various subcommittees. But it's interesting to see that in Centro, for example, that wouldn't have helped anybody at all.
Mm-hmm.
Well, I'm interested in hearing your views on a related issue, that of reliance. If the directors are relying on someone they think is expert or is giving them correct information, that turns out to be incorrect. Traditionally, they had quite a lot of leeway in that respect. It was only if there was a real red flag where, any prudent person would have appreciated that it was unsafe to rely on it. But in the
plain, manifest and simple of appreciation.
That one, yeah. And then the Tricontinental Royal Commission, however, thought that was too protective of directors and thought, no, directors have to be of inquiring mind. So how does that play out? What's the current position, given Centro and given the James Hardie litigation? Do you want to kick off on this one, Ray?
I think what the cases show is an increasing reluctance by judges to let directors off the hook. And so my best guess is that the liability of directors is going to be incurred in areas where yesterday boards thought that they could delegate and rely on third parties or inside or outside the organisation. I think we're moving away from, I think the courts are moving away from that. The difficult area is to work out what it is, what are the issues that the directors must decide for themselves with their own proper investigation. I know that John Middleton said if it's so obvious to any reasonable person, then you can't pass that on to somebody else. But that's not the end of it. And that's not the limit to the rule. I can't detect from the cases what the rule is. Perhaps there's no bright line in any event, and it might be that some decisions will be regarded as so important that reliance isn't good enough, that the board is there and gets paid enough money to do something more than act on clever third parties' advice, internal or external advisors. It's really a question of working out where's the line, and I can't see, at least under Australian or English case law, anybody even attempting to articulate a line, which means maybe it's an impossible task in any event. But I fear for boards that their responsibilities are going to be made tougher by the legal system, even without the intervention of Parliament.
You don't fear for them, you want to draw blood.
Well, I never feared for them very much, I know.
Well, Bob, can you detect what the rule is in this
Well,
regard?
look, I think it's really interesting that the case law lives in a kind of parallel universe to the statute here, because we actually have a statutory provision which purports to state a statutory rule in section 189 of the Corporations Act. And in the end, it really boils down to whether the directors have placed reliance on the advice of others in good faith after making an independent assessment of the information or advice having regard to their knowledge of the corporation and the complexity of structure and operations. That's what the statute says. I think Justice Middleton didn't refer to section 189 because he wasn't asked to, and he actually was asked not to, I understand. And that's the scuttlebutt that I've heard. But if you look at his judgment and you look at what was decided ultimately in James Hardie, I think they're consistent with that idea. Whatever it precisely means, what the courts are striving towards is some idea of requiring the directors, when they get the experts' advice and are about to make their decision, to stand back, to apply their independent judgment, using that word independent broadly, their if you like, their divorced or distant judgment of the expert advice they're getting, and asking a few sensible questions about it to see whether, as a matter of common sense, they can just follow the advice, or whether they have to look further for more advice, or whether they're to reject it.
Well, one other aspect of what we're talking about that was raised by Centro was this very practical issue of director workload. And to what extent that it is now so burdensome for directors with the volume of material coming either in paper or on their iPad, that, you know, honest people will no longer wish to become directors. So I want your views on, is it now too burdensome? Is the workload of non-executive directors, it's just not feasible to have that workload? And if that is a real problem, how are you going to solve it? Bob, I know you've got it.
Look, I know people mainly came here tonight to hear Ray, but I've got to set the scene because Ray is going to steal the show on this unless I have a go first. And what I want to start with is John Middleton's statement, Justice Middleton in Centro, where the poor directors pleaded that they had board papers, monthly board papers of 450 pages, annual financial statements. That task of producing those statements equated to over 3,000 pages of documents. And surely they can't be held to blame for what they overlooked. And Justice Middleton said, well, the board can control the information it receives. If there was information overload, it could have been prevented. Now, when that judgment was delivered, we all thought, well, just how can you go about preventing information overload? Because it does, at least in some companies, seem to be a problem. The larger the company, the more multinational it is, the more it's APRA regulated, to be frank, the more paper is generated. And so what do you do? Well, I've had a debate on this with a senior company chair in a financial institution, and he said after Justice Middleton's judgment was delivered, he counted the number of pages he had to assimilate for monthly board and committee meetings as chairman of the board, and the total number of pages was over 4,000 in 1 month. So he initiated a system that the main board every month would review the paper they'd received, and they would debate for 5 minutes at the end of the board meeting whether there was any paper they could have done without. And he'd done that by the time he discussed it with me for 6 months. And he said that so far the number of pages identified by the board as papers they could do without was 0. So that's not the solution. What is the solution to handling what I say is becoming an information overload? And I wanted to say that first because Ray is going to say, oh, that's
You
all.
can't say what Ray's going to say. Ray,
He's
you
gonna
say what you're going to say.
He's going to say it's piffle.
Yeah. No, you go ahead and say that, Ray.
I've got an example. In fact, I've probably got dozens and dozens of examples of appeal papers or trial papers filed, 10 lever arch folders, 20 lever arch folders, 50 lever arch folders, and the relevant documents are in one and sometimes half a lever arch folder. And I suspect, without having ever been a party to it, that board papers might be the same. One answer is that there are skills involved in selecting relevant things to read, and there's a real possibility that the person who puts the board papers together says better have everything so I don't get into trouble, rather than some thought going into what's necessary and what's not necessary. But my other answer is, if that's wrong, then the directors can't get away with once a month meetings with a couple of days preparation. If it means that they're directors of a company which involves a lot more work than first thought, pay them adequately and get them to do the work. I don't have a problem with that. If it's a tough job, you've got to spend the time on the job, and it means cross-directorships might have to be given up. Concentrate on the job you have to do that properly, and don't sit on 4 boards and do 4 jobs badly. And once again, the law will fix that. Sooner or later there'll be judgments which say this does not work. You don't spend enough time on the job and you'll pay a price, usually called damages.
But will there be judgments which say that you can select out of the 4,000 pages, the 6 pages you have to read?
No, a judge would never get it.
Yeah, but are there any other solutions we can think about? We've talked about supervisory boards. That certainly is a solution, isn't it? Because the board comes back to a more limited role, and therefore the paperwork that is required to deal with it is necessarily, I would have thought, more limited. But I think when you think about the board being reduced to that supervisory role, you see the problem that the board will cease to have sway over management, will cease to have the influence it needs to have for effective governance of the organisation. We've talked about delegation. Really, if you're a manager of a business and you've got a problem that someone is overworked, what you do is you shift the work to somebody else. Well, you can't do that by delegating to board committees and giving them each a chunk to do. At least only to a limited extent can you do that for the reasons I've indicated. Most of the things that board committees do, the full board wants to hear about and make a decision about.
Well,
So just a final thought.
Yeah.
Does this mean, as Ray suggests, that we're moving not only to limiting the number of board positions that directors can sensibly and safely hold? I mean, we used to see in our lifetime company directors with 10 or 12 boards. Now, I think for ASX 200 and even for ASX 100 in particular, you don't see too many with more than 4 maybe. And certainly if one of them's a chairmanship, it tends to be only a smaller number. So we're moving, but does that mean the trend is going to be that ultimately, as I suggested earlier, the professional non-executive director will actually become an executive?
Well, I'm going to delegate to our audience to see if there are any questions out there. Or comments. Andrew Lumsden.
I'm interested in, part of the role of the board is clearly to be collegiate, and I think one of the problems is that we tend to look at these problems from the emergency room when the day-to-day practice of life isn't actually about emergencies. But clearly in a number of small, high-profile issues that come before boards, they have to cease to be collegiate. And I think Justice Barrett talked a bit about it in the Harding penalty judgment, and I think there's a stream of kind of cases coming out where you've got to try and work out how practically do you break that collegiate spirit, and is the answer for boards to have access to better material, whether they use internal audit or their own separate appointed advisors or devices that allow them to kind of break that collegiality, if you like,
Well, it's an interesting issue, and I thought that one of the reasons why independent directors, the idea of them was thought up and promoted was to do exactly that. That is, sit there as a check on the people who are there every day and not buddy-buddy with them and say that's a great idea, but raise the questions and have the arguments. Now, it might be that the independent directors, if they're not fulfilling that function, you might have to look for a replacement. But that was why they were first thought of.
But I think that flies in the face of what behavioural psychologists will tell you happens in any group. You can put a bunch of generals in a room and ask them to come up with ideas, and you come up with the Bay of Pigs, or Gallipoli, or other great ideas. You know, I think the reality is that, you know, these biases are very entrenched. We're naturally collegiate animals, and I think that you need to move to devices that break up that collegiality, rather than trying to think that this group of people who 9 times out of 10 all work together with a common purpose are all of a sudden in a couple of high pressure situations going to break that down.
Andrew, it depends on what you mean by collegiality. In one sense, I disagree with you about breaking up collegiality. I think it's wholly desirable, but collegiality has to be accompanied by the ability to make an independent assessment, as the statute says. And so you mustn't be so collegiate that you're buddy-buddy and inclined not to exercise your own judgment. So that's the trick of it, I think. I think if you break down collegiality completely, you get, well...
Dysfunctional boards.
Well, I'm going to say, I was going to mention a particular company that often appears in the board. What you get instead is a local government sort of structure, a local council. And I don't think we want that. That is inefficient. And efficiency is still a major criterion for assessing the success of boards. I think myself that Justice Barrett was talking about procedure when he spoke about collegiality, and he was concerned that collegiality of the kind that he witnessed in that case was taken to such an extent that there wasn't a proper formal resolution and recording of decisions. And I believe that the collegiality I think is important is entirely consistent with proper, clear, articulated decisions and minutes of decisions. But it has to be accompanied by independence of thought, inquiring minds all around the table.
A CEO once told me that he regularly appointed someone as a devil's advocate on the board to, you know, artificially put up contrary arguments, which I actually thought was quite a clever concept. We've got another question over here. Yeah.
Peter English from Surrey Partners. It was actually on Andrew's point, something that both Bob and Ray mentioned earlier about the idea that the independent director should take the time to almost immerse themselves in the business and get to know the business quite intimately. Pick up Andrew's point about culture, which I think is sort of part of this thing. Isn't the risk that it raises this complex kind of decision for the individual who risks essentially that independence by getting too close to the thing, that their independence is compromised in a sense, because they think of this body corporate and they think of the whole and they think of the greater good and all of the issues that might be connected with the decision, and yet, you know, they're faced with this, the one honest man, the one who's going to, save the organisation from the wrong decision. It's hard to conceive of how that could practically happen in an organisation where there's so much going on.
Well, let me pass that to who wants to take that up, Ray.
Some of the literature suggests, I think as a means of dealing with that kind of problem, that the independent directors should be at least half or even a majority of the board, and they should caucus by themselves independently of the other directors, so that, and if that happens, they can form a collective, quote, independent view and go deal with that, take that to a board and discuss it, so that if that kind of thing works, I don't know whether that would work, but it's at least a part solution where they're not necessarily overborne. You could do the sort of court-martial thing too and have the independent speak first, or the junior independent followed by the next junior independent, and so on, before you get to the management directors, so that they speak last.
It does depend on the boards we're talking about, and we've been focusing on the biggest boards, and for most of them there'll only be one or two executives on the board, so a meeting of the non-executive directors without the executives present would not be much different from a meeting of the full board, and would not be a bad idea where there's an issue that's been brought to the board by the chair and by the chief executive, and the board wants to consider it. They might well ask the chief executive to leave them alone to talk about it for a while.
Well, just picking up when you talked about cross-directorships are on the decline, one country where they're not on the decline is in Norway. The reason why they are on the increase in Norway is because Norway has mandatory gender prerequisites, and so the same women are on multiple boards and they're all overborne and exhausted. So I'm just going to ask any comments on the shift. Europe is transfixed by gender issues on boards of directors. It's a big issue. I think we need to have a whole seminar on it next year, but I just thought I'd give you the possibility of closing remarks in the couple of minutes we have.
It's an interim problem, as there are more women qualified to be appointed or thought to be qualified by those who make the decisions, the problem will tend to evaporate.
Right?
I agree with that.
All right, well, I think we're going to wrap up there. We've had a wonderful session with our two speakers. We will have a lot more seminars next year, and I hope to see some of you at them. I think we can really develop a number of these themes, and this has been a great end to the year for us at Sydney Law School. So thank you, Ray.